That I usually talk about the opposite of what I'm asked to talk about. So I'm going to be true to my reputation and give you the private practitioner's perspective on the inspector's perspective. Okay? Do you get it? So what I have learned in my 20 years of being an environmental lawyer about enforcement in Canada of environmental law, and sort of the leitmotif is the question why. Okay, so there are a couple of parts to my presentation. The first part's going to be why is there an inspector at my door? And then we're going to lead into why would a government regulate and enforce for environmental protection? And then why is there no inspector at my door? And then finally, if there is an inspector at my door, ideally, and then I'll tell you ideally what. So why is there an inspector at my door? That question, one of the answers to that question, and why you would be asking it of yourself, is this is Canada. And for us, enforcement feels kind of un-Canadian. I don't know, do you know what I mean? Like, enforcement is really, it's conflictual, it involves bad feelings, consequences, discomfort of a truly un-Canadian nature. We would rather not be at either end of that situation. We don't want to be the enforcer or the enforcee. And I think that privately we can relate to that enforcement scenario best when we think about getting a speeding ticket. That really encapsulates what you need to know about the emotions involved at the level of the enforcee, so the person who's getting inspected is like, what the hell? Everybody's driving on this highway. How come you stopped me? And then you start thinking, oh, it must have been my car, or like, oh, he must have a quota. I'm from Montreal. We're kind of paranoid about stuff like that. But so right away you're thinking, it's not fair, they're picking on me. Or if he has a quota, what am I saying? I'm saying he's enforcing, yes, but not for the right reason. And so from a legal perspective, these are all things that I'm already sort of listing in my head as grounds for, appeal of this thing. So enforcement is un-Canadian. I want you to really keep that in mind, because it's very American. And I'm going to come back to this in a couple of minutes about why it matters that enforcement in the U.S. is done vigorously by many agencies, and why it might be a problem if it's not done by many agencies or vigorously in Canada. So the inspector, right? I said I was going to talk to you about the inspector. How does he feel? So he's standing there, he's ringing the doorbell, and he's thinking, what? Does he feel like I am representing Canada in the fulfillment of its dream of running a green economy? And I have the full support of my department, of my government, and of the population at large. Does that person feel that way when the doorbell is being rung? Or does that person maybe not think about that and just think, I'm an enforcer, and what I want to do is find violations? Because I've been told in the past by somebody who used to head up enforcement at Environment Canada that like inspections and investigations guys, they're like sort of like guard dogs, you know? They're like, let me at it, I want to sniff out like the violations. And that's how you want them to be, right? You want them to be very keen to find problems that will be fixed, and in the end that's all really good because it's going to lead to compliance, and then the law will be respected. So maybe your guy is not so philosophical, but he's really keen to find violations. Well, why would the government, so say the guy is standing there thinking, my government is backing me. You hope that that's what the guy is thinking. I keep saying guy. This, you know, l'usage du masculin, ça inclut le féminin, okay? Why would the government send the guy to the facility in the first place? In industry, we don't ask ourselves those questions. And by in industry, I mean lawyers in private practice who represent clients in industry. We don't spend any time thinking about policy or government programs or budgets or priorities. Like, we have no clue. Why? Because we bill by the 6-minute increment and nobody pays us to think about policy. And the result of that is that we actually know nothing about policy. So we couldn't tell our client why the inspector is standing there unless the inspector says, you know, the neighbors called us because there's this green stuff like on their property and they think it's coming from your property. I want to take a couple of minutes to talk to you about why it's important to ask yourself, why would the government enforce the law, okay? And always think about the flip side. Why would they not enforce the law? What's in it for them to not enforce the law? Again, like, we're Canadian, right? So we have this image of our country as being like really environmentally friendly. And so the reason why we would enforce is because we're so kind of green and nice and Canadian. But, you know, sometimes you just need to look at the facts. And they might not correspond, again, to the feeling that we have about what our country is like. So I'll tell you the truth about why our government enforces laws. Number one, international commitments. So Canada signs on to international accords, like the Basel Convention and this convention and that convention, and then they come home from those summits, and preferably or presumably they've already got the provinces on board, and all the jurisdictions will adopt legislation, and they'll bring the provisions of that accord into force under domestic legislation, and then they'll implement, you know, through environmental programs, these commitments that they've made to the other countries of the world in the interest of saving the environment. But what if they don't? So, you know, the UN Convention on Biological Diversity, Canada ratified. We were the first to ratify. The U.S. didn't. But what if we don't? So what if we say at the UN level we're going to protect, I don't know, 7% of our territory by 2017 for the benefit of endangered species, and then we don't? Is there a consequence? Well, I'll tell you the answer. No. There's no consequence. You don't have to do it. It's just a UN convention. I'm a corporate lawyer, okay? So you don't do it. So what does it feel like to be a member of the Canadian delegation? So you work for like NRCan or Environment Canada, whatever, and you show up at The Hague or wherever, Shanghai, for the convention. It's like the 27th meeting of the parties of whatever, and it's like Canada for the 19th year in a row has failed to meet its commitments under this convention. It sucks. It's really humiliating, and it's really bad for the morale of you and your department. And it makes you feel like quitting the civil service because you had this idea of Canada that led you to join the civil service, and then the reality ended up being very different. And no matter what you do, You can't change that. You personally are not going to be able to change the fact that the next time you go to like COP29, it's probably going to be the same thing. But in theory, international commitments are what results in Canada in the adoption of environmental laws and their subsequent enforcement. Now, there's a kind of international commitment that does have teeth. It's called trade agreement. And if you read my paper, which I was saying earlier is very convoluted, it's kind of a data dump. But, you know, think of it that way and then try and just use the data. You'll see that basically my paper posits the following hypothesis. You can trace the arc of environmental law in Canada by tracing the history of our trade negotiations, starting with the FTA through NAFTA and sort of beyond. Basically, our trade negotiations with the U.S. have resulted in us scrambling to try and build an environmental law system that looks kind of like the U.S. system, because the U.S. has said, you know, probably rightly, it wouldn't be fair for our companies to have to comply with our environmental laws, not just our laws, but our enforcement. And meanwhile, in Canada, you have not got the whole range of environmental tools that we have. You don't have civil penalties, you don't have civil suits, you have no staff, you have no budgets, and I go on and on and on. So if you read the paper, you'll see how I sort of build this argument that free trade is really, and trade agreements are the one kind of international agreement that actually has a consequence, it sort of yields results in Canada in terms of our environmental setup. So that's one reason why a government would regulate and enforce in Canada. The second one, and I think Heather was talking about this, it's public demand, right? I mean, you are the government, right? So if the public's like, hey, this terrible thing happened, you have to say something. I mean, presumably, you're being granted all these powers under the Constitution in order to respond to the needs of the public. And if the public is making a lot of noise around something, then you will respond to that. Now, in the paper, I say that that's kind of a dangerous way of running an environmental program, because it's, in French, we call it aléatoire. And what you don't want from a civil liability perspective as a government is to have your actions seem arbitrary and kind of random, because to the extent that you're not in a position to say that there's coherent structure around the way you apply the law and how you respond to things, you are at risk of getting sued. And that, you know, somebody was talking a lot about risk management. In fact, I think everybody was talking about the whole risk-based government policy structure. That's really based around preventing the government from incurring civil liability. So again, we're really far from protecting the environment here, but we're very, you know, it's something that I can understand. As somebody who acts for business, I know about the bottom line. And if the government says our books are not going to look good if we have massive liabilities resulting from lawsuits that we face in connection with the way we enforced the law or didn't enforce, or were sort of unfair in how we enforced, then that's not good. That's just a bad thing. And remember NAFTA, Chapter 11? NAFTA Chapter 11 can be thought about along those lines, but from the perspective of a foreign investor. So you're a foreign investor, you come here, you're sort of investing all this money, hiring people, whatever, and then say the population turns against you because they think what you're doing is, you know, they just don't want it. Often the reaction of the public can be very swift. It might not necessarily make a whole lot of sense, but it will invariably be tied to some extent to an environmental concern. So then the government says, oh dear, like there's an election in whatever, 8 weeks. So they just pull your permit to operate, or they say, we said you didn't need an environmental assessment, but we changed our mind, or, whatever. They just do this kind of ad hoc reflex thing, and you're the foreign investor, and you're shocked, especially if it then turns out that the government adopts sort of an emergency law and freezes your whole project, saying you can't do this anymore. My computer just logged out. So what do you do then? Well, you file an NAFTA claim, and chances are the government will settle with you if it's Canada. And what I want you to think about again, and quickly right here, is if you're the federal government and you're paying because of something a provincial government did, it's just really annoying. So there was a government a little while ago that said the next time a province pulls one of these environmental stunts, and we end up having to pay $350 million under a NAFTA claim, we're going to withhold that. We're going to set off that payment in your transfer payments, which I think is brilliant. I'm not sure it would work, but just the threat of it, to me, should knock some sense into the provinces, because I don't like it when people disrespect environmental law by using it for purposes that have nothing to do with environmental protection. So, just quick example, you see a company sliding into bankruptcy. You want to give yourself priority over all the other creditors of that company. So what do? Slap an environmental order against the company and then say that that order gives you priority against everybody else. It's not because you really worry about the environment necessarily, but what you really want is priority so that you can get the most money and the other creditors don't. That's not right. From the perspective of respecting environmental law for what it was meant to do, which is protect the environment. See how this is a really coherent speech? If you can walk away from this with a couple of thoughts that are sort of different, I'll be totally pleased. So, final reason. So we had public demand, and you saw how it's a bit tricky, because it might not result in orderly enforcement. And I think Heather was saying, you're trying to do orderly enforcement, but you do have to respond to public demand, and it's tricky. The last one is court orders. So why would a government regulate and enforce for environmental protection? Well, a court could tell them they have to do it. Remember Massachusetts versus EPA? No? Of course you do. Massachusetts versus EPA, it was like Massachusetts and a whole bunch of other states under the Bush administration said to the EPA, you have to analyze whether greenhouse gases are covered as pollutants, or whatever they call them, under the Clean Air Act, because the Clean Air Act says that you shall analyze substances, and when you terminate your analysis, if it turns out that, lo and behold, they are pollutant as defined by the law, then you have to do something about it. So EPA under George Bush was like, yeah, I don't know, whatever. But the way the Clean Air Act and the other main environmental laws in the U.S. are drafted, the government has to do stuff. And the lovely thing about shall versus may is that if you're an NGO or you're concerned anybody, you can go to court and just say, make them do it. They're not doing it. The law says they have to do it. So make them do it. So the Supreme Court said, EPA, do your job. And I'm sure the EPA was delighted. I'm sure they were like, oh, because George Bush didn't want them to do it. But the legislature, or whatever, what are they called? The Congress, so the House and the Senate in the 70s in the U.S. realized that they needed to put a check into the statutes to prevent somebody from coming along and saying, yeah, you shall do all of these things, but guess what? I'm not going to give you any appropriations this year. It's called an unfunded mandate. So you won't have any inspectors, and you're just not going to, you can try to do your thing, but the fact is you're not getting any money. But by allowing the public to sue the agency, to force it to do its job, you give the courts, and this conference is about court practitioners, you're giving the courts a role in environmental protection that they, I maintain, do not have in Canada. They don't have it. So, like, you can make a list of the leading environmental cases in Canada. It's a really short list. And that's because there's not really any reason for a government from a balance sheet perspective to consider that it's less risky not to enforce. It's way more risky to enforce than to not enforce in Canada. So why is there no inspector at my door? Well, I just told you the reason why, most of the time you won't get inspected and there is no sort of program or massive plan, et cetera, is because there's no inspector at my door because there's no inspector. Like, just look at the number of inspectors we have in Canada. There used to be a joke that we had more regulations under CEPA than inspectors for CEPA. I think it's better now, but, I'm not sure. No, see, there you go. See, there's progress. The other thing is, I've already told you this, there might not be any appropriations. So, again, former head of Enforcement and Environment Canada told me a story once about sitting before a standing committee of the House of Commons and being asked, probably by Charles Katcha, so have you got enough money to run your enforcement program? And he had these two kind of big guys on either side of him from I don't know what department, leaning in to make sure that he said, and I believe he told me his answer was like, I don't know, I take the fifth, or no, that's the U.S., but no comment, or, call my lawyer. But he just refused to answer. He didn't say no, he didn't say yes, but he just said, I'm not going to answer that. And he was hoping that Charles Katcha would hear his cry for help. And indeed, the House of Commons Standing Committee published what I consider to be the most important paper on enforcement in Canada, on federal enforcement in Canada, and it's a 1998 report called Enforcing Canada's Pollution Laws, the Public Interest Must Come First. Why is it so important? Well, first of all, it's really well written, but second of all, it's published by a House of Commons Standing Committee. Do you guys know who's on the House of Commons Standing Committee on Environment and Sustainable Development these days? I don't. I mean, I'm not proud of it, but that period of Charles Katcha sort of standing there and saying this is really important is, in French we say, elle est révolue. La période est révolue. So if we want to come back to that, we need to start over to give Parliament and parliamentary committees a role in protecting the environment in Canada. So no inspector, no appropriations, no policy. And then my next point is no law. So those two go together. If you have no enforcement policy, then anything you do by way of enforcement is open to potential attack on the grounds that it just is incoherent. That's why it's so important for there to be a policy. But policy is a double-edged sword. You know why, right? Because then if you publish the policy and you tell people what the policy is, then what are they going to do? Like, Defense Counsel, hello? Then you say, you didn't follow your policy, right? So they can either say you have no policy, you don't know what you're doing, or you violated your policy. But the fact is you need to have a policy. And the policy is the piece of paper that tells you, we have a law in the books. This is how we, the government, are going to go about turning this into reality on the ground. So it's great not to have a policy if you want to stay out of trouble, but if you don't have a policy, make sure you don't enforce. And this brings me to there is no law. Now, if you have an environmental law and you don't enforce it, by a show of hands, what is the common law rule? Do you have to enforce a law, a statute, under the common law? Okay, yes? Jack is saying no, no. Thank you. There is no, okay, so we're all lawyers here. There is no common law duty to enforce a statute. In the U.S., again, in the Clean Water Act, Clean Air Act, CERCLA, whatever, they put the duty to enforce into the act by saying you shall do all these things, and they put the public in charge of enforcing against the enforcers in case they drop the ball. But in Canada, we have acts that say, you know, the minister may do this and the minister may do that. Our common law says, you know, minister can do whatever he wants. Laurentide Motel in those other cases, they tell you, you know, the difference between an operational and a policy decision. Well, you only get in trouble when you get into operational, but if you don't enforce, then you don't have that risk. And you don't have to enforce because the common law says you don't have to. So who would say that you have to? Again, read my paper. The NAFTA Environmental Side Agreement says you have to. And the previous people here in Ottawa had a hard time of it when the last U.S. federal election rolled around because both Barack Obama and Hillary Clinton said, we're going to reopen NAFTA. If we get elected, we're going to reopen NAFTA and we're going to take the Environmental Side Agreement and stick it into the NAFTA text to make sure that that's enforceable. And so what were they saying? They were basically saying Canada is not enforcing its environmental laws. That is not fair to American business. And if we get elected, we're going to do something about that. So that was like, I don't know, 4 months before the federal government adopted the Environmental Enforcement Act. So in my paper I say, well, I think there might have been a connection between the two, but anyway, and so then the federal government in Canada said, oh shit, like there's no way we're going to reopen NAFTA. That would be a disaster. I think everybody in industry agrees. So they said, fine, we'll ramp up our we'll do all these great things. And then after the dust had settled, I personally think that somebody with sort of like maybe more of an economics view of things said, this doesn't make any sense. I don't want to enforce environmental laws. It costs a ton of money. And really, what is the upshot of enforcing? Everybody's angry at you. You know, the NGOs will be angry at you no matter what. And industry will be angry. And so the NAFTA side agreement doesn't say we have to have environmental laws. It only says we have to enforce them if we have them. So guess what happened? We got rid of them. We got rid of the Fisheries Act, we got rid of the Navigable Waters Protection Act, we got rid of the Canadian Environmental Assessment Act, and that basically puts the federal government in a position where it can say to the provinces, hey, you guys, you know, you wanted jurisdiction over environment. You keep saying environment is a provincial matter. Well, guess what? You've got it. We're giving it to you. You can have it. You can be the environmental superstars that you've always wanted to be or not. And if you're doing environmental regulation or not gets us into trouble under international agreements, we'll just take that off of your transfer payments going forward. So I think I'm going to wrap up here with a quick statement, which is the following. If there is an inspector at your door, ideally, so this is the ideal super future scenario, you, the industry person, you know what their enforcement policy is, their priorities, and what their practice is, because the information about all of that is available on the internet. The internet. It's where governments put information about policy. And the US EPA has a lot of that information on its site. Your employees, they'll know what to do when the inspector shows up. If they don't, you've already dropped the ball in a very big way. And finally, the inspector, him or herself, will have a deep knowledge of your industry, about your file, the challenges you are facing as a company, and the work that you're doing to face those challenges. He'll know that before he even walks in the door. If any of these are not true, then somebody forgot to do their homework. Thank you.
Thank you so much. So we have 3 questions that we've received. The first one is, well, I'll just read it. My neighbor spilled gasoline on his residential property and didn't disclose or clean it up properly. My children and I had to vacate our property because of the air quality, etc. No one in the city knew what to do between the fire department, the city, etc. An inspector finally did come but wasn't given consent to enter the property. What do you recommend that the regular citizen do in this kind of situation?
That's interesting. Because, you know, here you are. I'm pretending I'm the person who's smelling the neighbor's gasoline, and I'm thinking, wow, what do I do about that? There's an environmental law angle to that, and then there's a common law angle to that. The common law angle is to say that is a nuisance. That is a nuisance that is preventing me from enjoying my property, and also I suspect that it's putting my health at risk and that of my children. But are you going to sue them? No, because you want something to be done right away. So I would probably have called, in Quebec it would be Urgence Environnement. And the reason why it's a good idea to reach out, normally your municipal inspector should be pretty good at this. So by calling the municipality, you should normally get a response where the municipal inspector is going to call a whole bunch of other people. But the same works for if you call the provincial environment ministry. They will also have a whole bunch of phone numbers, and they'll make sure that there's a concerted sort of response to that. Yeah.
Thank you very much. So we have a question and then a comment. So the question is, why are the most effective tools in environmental compliance, i.e. trade agreements, negotiated behind closed doors?
They're not negotiated behind closed doors, because I know this because I was participating last year in the in talks around the Canada-EU Free Trade Agreement. So I think it's more that there is a generalized failure by academics to understand and politicians to communicate how fundamentally connected environmental law and trade law are. And again, in Canada, we are particularly susceptible to claims that if something is about trade, it must be evil. And if something is labeled as environmental, it must be virtuous. We need to be more critical. We need to know that everybody has a vested interest in something, and it's not because you say that it's environmental that it really is. The principal reason people get in trouble under trade agreements is not because they're trying to protect the environment, it's because they're using what they call an environmental measure to achieve an objective that is completely different. It's normally to give an advantage to a local company or to some other interest. And I think that most people would agree that that's not right. So if people understood more, they wouldn't be so concerned.
As I said, we had an interesting January term visitor here, a faculty who was talking about how trade can be used to help within the environment. For example, facilitating green trade, green technology investments. That was quite interesting. Okay, and this is just the closing comment, and then we'll move on. Somebody wanted us to know that the recently deceased Justice Scalia, in his dissent in Massachusetts versus EPA, apparently objected to CO2 being defined as a pollutant under the Clean Air Act. He said that by doing so, the majority opinion was defining pollutant so over-inclusively that it could catch everything from frisbees to flatulence. So that's
well, and I think that's why you want to have the courts involved, because it's good to have debate on these issues, and you want smart people debating seriously and leaving no stone unturned. Again, the biggest problem in environmental law and policy is a lack of critical, serious, open, wide open-eyed debate. Thanks.
Thank you so much. And now we're going to move on to Fred Maves, if you would like to. Thank you.
I guess it's almost good afternoon. Just by way of background, I've been a prosecutor with the Ministry of the Environment and Climate Change for 14 years. I started out as a criminal crown downtown Toronto, and soon discovered I didn't want to do that the rest of my life. And so I moved to prosecuting for the Securities Commission, and I was in the securities industry for 17 years. And at one point, the brokerage firm I was working for decided that all the senior people were making too much money, so they let us go. And I was out of work for a year, and I saw an ad in the ORs for a litigator at the Ministry of the Environment, knowing absolutely nothing about environmental law, and got the job. That was 14 years ago, and here we are. The second thing I want to mention is that I'm going to keep my comments fairly high level about the initiation of compliance actions, the difference between inspections and investigations, for three reasons. First of all, my paper basically covers that. Secondly, there's a bit of overlap in the program about other people making the same determinations. And third, I'm the last speaker before lunch, so I want to keep it kind of high level. As Jamie mentioned, at the Ministry of the Environment and Climate Change provincially, we have two types of provincial officers, inspectors and investigators, and their roles and their responsibilities are extremely different and well defined. I noticed that with the Environment Canada and Climate Change, and provincially Ministry of Labour, their people wear two hats, and they have to determine at which point when they're doing an inspection when they have to take the one hat off and put the other hat on. And I think that's a little more difficult than it is with our people, where they have defined hats. Although it's not a perfect world, I should just tell you, a couple years ago I got a call from a senior supervisor for our investigative branch in Northern Ontario, and he called me up and he said, I just want to know whether or not we have a problem. He said one of our inspectors was assigned an inspection at a very remote campsite in Northern Ontario on an island that nobody had been to in quite some time, and there were concerns about waste treatment, water treatment. So he made arrangements to go out there by boat, and he arrived, but he had taken an investigator with him. And so when they docked the boat and were met by the owner of the campsite, they both identified themselves and then proceeded to walk around the campsite. And as the inspector found things and wrote them down, the investigator was right there with him and was collecting evidence. And then they both got back on the boat and came back, and he said, do you think that's a problem? And I said, absolutely. You can't have an investigator walking along conducting an inspection at the same time. So you can tell him that just about everything that he collected is inadmissible. So he phoned me up, the investigator phoned me up a couple of days later. He said, I understand you think I had a problem with how I did things. And I said, absolutely, you shouldn't have gone on that inspection. He said, well, I had to. I said, why did you have to go? He said, we needed two people to row the boat. So Jamie had mentioned the ministry's compliance policy applying abatement and enforcement, and I'll refer to it briefly too. It's referenced in my paper, and it notes that the main incidents that we become aware of may occur through different avenues, and the compliance policy names a few, but it's been my experience as a prosecutor, keeping in mind that I get my cases from after an investigation's been conducted, so the investigator will get a referral from the abatement officer who's done a number of things, gotten information from a number of different sources, but then has designated referrals to investigations, who then does an investigation and then passes it on to me, that the majority of matters that I become aware of are usually through pollution incident reports. That could be a neighbor in the gas on the sidewalk type. It's usually somebody reporting something that we become aware of and then send people out. A spill report or a spot inspection, one that's usually not planned, where the inspector just shows up because there's been some concern about some operation, and they show up and discover something, and it turns into an investigation. So those are the three main things that I've seen that are the basis for inspections and investigations, but it could be much more far-ranging than that. There's reference in both Jamie's paper and mine to a case called Crompton, and it may be of interest to you to hear a little bit about that case. It was actually my case, because it was a fairly recent decision by the Ontario Court of Appeal on defining the inspection powers of the Ministry of the Environment and Climate Change. It was my very first prosecution for the Ministry of the Environment. It went all the way to the Court of Appeal, unsuccessfully, I might say. But just by way of background, Crompton was a chemical company. They produced chemicals, had several branches throughout Ontario, and in their Guelph branch, they called, on a Saturday, they called our Spills Action Center, and which is a 24-hour, 7-day-a-week service that takes calls on incidents. And Crompton said, we have had a discharge of cooling tower water, which wound up in a local creek. And that was all the information they gave. And it's up to the Spills Action Center to determine right then and there, is this something that warrants sending somebody out on a Saturday right away, or can I wait till Monday and we'll have one of the inspectors look after it then? And they decided, well, it doesn't sound all that terrible, so we'll wait till Monday. So one of our inspectors shows up at the Guelph office on Monday. He's got this report. He knows the environmental officer at Crompton, so he phones him up and says, I got this call about this cooling tower water stuff. Can you send me a report? You're under the spills section of the Environmental Protection Act. You're supposed to tell me the details of the spill and the circumstances thereof and what action you've taken to make sure it doesn't happen again. Can you just send me a report and detail those things? And the environmental officer had dealt with this inspector before, so he said, sure, no problem, I'll send it to you in a couple days. So a couple days go by, nothing comes in, so the inspector calls him again and says, I still don't have that report. And the environmental officer says, well, tell you what, now the lawyers are involved, and they're saying not to give you that information unless you issue a director's order. And if you issue a director's order, then we'll give it to you. And the inspector says, well, under our legislation, I don't have to give you a director's order. All I have to do is ask for it, and you give it to me. And the environmental officer says, well, I'm not going to do that. So there's this back and forth for several weeks. And finally, the inspector issues one of his own orders to Crompton, and they provide the information. But he refers it to our investigation and enforcement branch that decides that what they've been doing is hindering or obstructing a provincial officer in the execution of his duties. So they charge both Crompton and the environmental officer with hindering and obstructing a provincial officer. And I get the prosecution. So at trial in front of a justice of the peace, the justice of the peace said, well, the environmental officer was only following orders. It wasn't really an intentional refusal to provide the information, so I'm going to acquit him, but I'm going to find Crompton guilty. So they appealed to a provincial judge who said, well, ministry got the information eventually, so I don't know what the big deal is. And I thought, well, that's not good. So I wanted to go to the Court of Appeal, but I needed leave. I had to get leave from a appeal court judge saying that this was a matter of public interest. And so I thought, well, the determination of how far inspection powers go is a matter of public interest, so we'll try it. So went to the leave application, and just purely coincidentally, the appeal court judge who was hearing the leave application was one of my classmates at law school. And so she walked out and sat down and said, "Good morning, Mr. Mapes. How are you? It's very nice to see you. How are things going?" And I said, "They're fine. Thank you very much." And so we made our arguments, and she said, "I'm going to be about 15 minutes in chambers to make my endorsement," got up and walked out. And defense counsel ran over and said, "Boy, you must be in the Court of Appeal a lot. They know you by name." I said, well, "Tell you what, buddy, I went to law school with her." Anyway, so she granted leave, and we were on in front of the Court of Appeal, and I thought I had a pretty good case. And so on the panel was Justice Scalise, who coincidentally was the dean of Western Law School, and I went to Western, and I would have been better off with a Western sweatshirt than my gown's on, because I stood up, and within 30 seconds she was on me about how the powers of an inspector under the EPA did not include a telephone call. And where she was coming from, if you look at the way 156 used to be, it's now, for the most part, the same, except now you can call by phone. Was it included things that an inspector could do, and all of them were like entering any place in which the provincial officer reasonably believes a contaminant is being discharged, entering a place where the officer believes it's likely to contain documents, entering a place where the officer reasonably believes that there's a permit required, entering any property for which a record of site condition has been filed, entering. So Justice Scalise said, "Where's the power to make a phone call when everything is enter? It assumes a physical presence." And I said, "Well, there is a section that says that the officer can also make reasonable inquiries of any person orally or in writing." And she said, "Yes, that's assuming he's there in person." So I thought, well, this isn't going very well. So after about a half hour of intense questions from Justice Scalise, it was then lunchtime, and the panel said, "Mr. Mapes, we really haven't allowed you to make your argument. We've only been questioning you for a half hour. So tell you what, you go away, have lunch, and come back. We'll give you another 20 minutes. So I went away, had lunch, came back, and the 20 minutes weren't any better than the half hour before lunch. And they came down and with their decision that said, the officer's not permitted to make inspections by telephone. And in fact, you charged Crompton with the wrong section. Rather than hindering or obstructing, there's an additional subsection of the same section that says you have to provide information to a provincial officer. And if you charged them with that, we might have agreed that that was the proper section, but you didn't. So anyway, for a while, officers were told that they could not make inquiries by telephone, but eventually the section was changed and now they're permitted to. And it's particularly useful in Northern Ontario, where the distances are fairly great, and it allows an officer for lesser incidents to actually make a phone call and make determinations as to whether or not follow-up's required. Also, I've indicated in that policy, it sets out the types of tools that are available to inspector. There are numerous, but once again, from my perspective as a prosecutor, the one I see the most is where inspections conducted, a provincial officer realizes that things need to be corrected. They want to give the entity time to make those corrections. So what they do is they issue a provincial officer's order, which they're entitled to do it. They're usually quite detailed, and that sets out what the expectations are as to what remediation will take place and specific timelines as to when they have to be completed by. And they might be sequential. For example, hire an environmental consultant to prepare a report. Once the report's prepared, file the report with the ministry. Whatever is determined in the report, follow through and make sure that it's completed, that type of thing. So what I see typically is where those requests in the order either are not complied with at all or not complied with within the time parameters that are required. Of course, there's a right of appeal to the inspector's director to make changes to the order or toss it out completely. And after that, there's a right of appeal from the director to the Environmental Review Tribunal. What's interesting is that, as I indicated, the powers of an inspector are fairly well defined. The Court of Appeal basically said even where the power of an inspector is fairly well defined and wide ranging, we will strictly construe exactly what those powers are. And that's understandable because they really are quite imposing as far as what they can do when they arrive and speak to individuals or arrive and request or demand documents from a facility. The powers as set out for an investigator, on the other hand, are pretty circumspect. It's just, for example, under the Environmental Protection Agency, Environmental Protection Act, it merely states a provincial officer may investigate offenses under this act and may prosecute any person whom the provincial officer reasonably believes is guilty of an offense. So compared to 156, that's pretty limited and not extremely detailed. There was mention made of law coming out of the Supreme Court of Canada about how you differentiate between an inspection and an investigation. And as you can appreciate, especially when it turns into a prosecution, what evidence was gathered in the course of an inspection and when the delineation ends and an investigation takes over and that evidence is collected is pretty crucial. So in a case called Inco, one of our cases, an inspector showed up at Inco to conduct an inspection and immediately became a little suspicious about whether or not there was violations that he was seeing, left and went back. And so the whole issue was, well, you know, at one point did he stop his inspection and start collecting evidence for an investigation? And the Court of Appeal said, well, an inspection becomes an investigation when the inspector has reasonable and probable grounds to believe that an offense has been committed. Well, the problem with that, in my personal view, is that reasonable and probable grounds is not a concept that an inspector would always be comfortable with. It's really a concept that policemen, investigators, that sort of thing, they're trained to assess when they have reasonable and probable grounds. An inspector, on the other hand, it's a little difficult for them to say all of a sudden, oh, all right, well, I've got enough information, I've got reasonable, probable grounds. Fortunately, the Inco decision went the way of the dinosaur when the Supreme Court of Canada came out with two companion cases, Jarvis and Ling. And you'll hear a lot about that. I'll just tell you a little bit about it because that factually it's fairly interesting. The Canadian Customs and Revenue Agency has two arms, just like we do. They have an auditor's function and a fraud investigative function. And so, just like our inspectors or investigators, and there were two companion cases that went to the Supreme Court of Canada at the same time. And they were Jarvis and Ling. Mr. Jarvis had a late wife who was an artist, and he was selling her paintings, and they suspected that he wasn't declaring the full amount that he was getting for them. So the auditors decided to set his income tax aside, start looking at it, and as they looked at it, they suddenly began, little bells and whistles began to go off that maybe this was a little more than just not putting in the right numbers in his income tax return. With Mr. Ling was a hobby farmer. He was also a very wealthy doctor, and they suspected that his farm, which was never going to be profitable because he was a doctor, not a farmer, he was deducting exorbitant amounts for a hobby farm that was never going to make any money. So same thing, the auditors were looking at him, and once again they began to wonder whether or not there was some fraudulent activity involved. So the whole issue in both Jarvis and Ling became when the auditors should have twigged that they were done, they weren't gathering evidence for the fraudulent people anymore, they would turn it over to them. But how do you define where that line is? So Supreme Court of Canada basically did away with the whole concept of reasonable probable grounds, fortunately. And what they did was they set out a number of factors, factual factors, that a court should apply in determining whether or not you've moved from an audit function to an investigative function. And Jarvis and Ling have been applied ever since. Of course, when the two decisions came out, the immediate reaction from us and other regulators was, well, okay, this is a federal statute. Does it apply to us? And Supreme Court of Canada basically said, yes, it will apply to regulatory organizations, even if they have a different structure than with the audit and the fraud function than that the agency that we were reviewing had. So the whole determination for the Supreme Court of Canada and Jarvis and Ling was doing away with when the inspector had reasonable probable grounds to what was the predominant purpose that was occurring when they were starting to actually look at this. Was the predominant purpose an audit function, or had it moved to a predominant purpose which was a more of an investigative function where you're actually collecting evidence for the prospect of a prosecution? And there's reference to the 7 factors that the Supreme Court of Canada set out that a court should look at, and Jarvis and Ling have been followed ever since throughout the country as to being what should be applied when you have to make that determination. In my own personal experience as a prosecutor, because we have the 2 defined roles, inspectors and investigators, and both types of provincial officers have been trained as to how they interact with their counterparts in the other agency, I have had very little trouble convincing a court that our ministry follows Jarvis and Ling. Haven't had, in my own personal experience, haven't had any arguments that there was tainted evidence collected. Fortunately, the 2 guys in the boat, because of their discussions, that never went ahead. Didn't have to deal with that one. But other than that, I really haven't had an issue. So those are my comments, and I'm happy to take questions before we head off to lunch.
Thank you very much. So, would you like to present your question? If anybody else in the room has any questions, please feel free.
I just wondered with the Jarvis and Ling issue and your clear division of roles, when the inspectorate or the abatement division has done its inspection or abating, and they have reached a point where they think, no, this should go to a more serious to prosecution potentially. Do they transfer the entirety of their file to investigations, or what do they tell investigations?
Okay, they prepare what's known as a referral, which is a document which sets out details as to what they've done so far, just in general, and what their concerns are. It goes to the investigations branch, it gets assigned, and then the investigator will generally start off by following up with the abatement officer, and what the investigator is entitled to is what's been collected by the inspector up to the time of referral.
Thank you.
Yeah.
Any other questions? Yeah.
Oh, Jack.
Oh. You don't need the mic. Oh, okay. Yes, for the online people.
Thanks, Fred. That was illuminating. Can you talk a little bit about what happens, in the initiation of a prosecution, how the Crown brief comes to a Crown investigator, how there's charge screening and that sort of thing, the interplay, and then ultimately the laying of charges? Just interested in the dynamic of that.
Sure. Just so you know, Mr. Coop used to work at the Ministry of the Environment, is now a very prominent defense counsel. So, yeah, once the investigator has completed their investigation, they compile what's known as a Crown brief, which contains statements from the witnesses, exhibits, documentary evidence, any videos they might have, that sort of thing. I understand our ministry is fairly unique in that our briefs are electronic. They're in PDF format. And so what we do is, unlike in criminal circumstances where a police officer will just go and lay charges once they have reasonable probable grounds, and then a Crown attorney becomes involved. Before charges are laid, our Crown counsel review files to make sure that they're satisfied that A, there's a reasonable prospect of conviction, and secondly, that it's in the public interest to proceed, and that there's sufficient evidence to warrant a prosecution. For the most part, our investigators have been very well trained, and usually everything that's required is in the brief, but there is that screening process that our Crowns do just to make sure that everything's okay. And then once they say that it's appropriate to go ahead and initiate charges, it goes back to our investigations and enforcement branch. We also get involved in the wording of the information, the actual charges themselves, may make some recommendations as to whether or not there's another way of considering the wording. And then the investigator will go ahead, get approval to lay the charges, and typically the Crown who has screened the brief will also become the prosecutor for the brief, since they're inherently familiar with the evidence. Jamie, that's not fair.
Not very fair. In 2005, the statutes were amended to include minimum fines and sentencing considerations. And I just want to know if you think, I'm seeing more sentencing considerations, but not that many minimum fines in environmental statutes. Just to comment on both, and if you think they're helpful for prosecutions, et cetera, what impact they've had.
Yeah, what's Jamie's getting at is that along with the concerns about a lot of spills in Sarnia, there was a review of legislation, including the Environmental Protection Act and Ontario Water Resources Act, and they came up with a new way of approaching penalties. First of all, for some of the offenses, such as discharge of a contaminant causing an adverse effect, there were mandatory minimum fines for individuals and corporations. And it also set out a two-tier set of penalties, one for what might be known as just regular offenses, and those for the more serious offenses. And the fines were fairly substantial because they could be imposed not just for the offense itself, but per day. So the fines that you were looking at were much higher than what they might have been before. And so initially, Jamie, the reaction of justices of the peace that are usually dealing with like Highway Traffic Act fines was that the fines that we were seeking were much higher than what they were used to. And the initial reaction was, well, even though the government says that these are mandatory minimums, I have my own discretion, and if I think they're too high, I'll reduce them. And we began to appeal those and weren't entirely successful because the Provincial Offences Act says that justice of the peace can reduce a mandatory minimum in exceptional circumstances, whatever that means. And but lately there have been some higher court decisions saying that mandatory minimum has changed things and that's now the starting point. It's not zero anymore. And so hopefully going forward we'll get much more response from justices of the peace than maybe we did when they were first imposed.
Thank you. And so now we have, which is one of the benefits of this format, we have a question for Vancouver, which is, can an investigation and an inspection continue at the same time? For example, can you continue to inspect and induce compliance going forward while also investigating or prosecuting for a past action?
The answer is yes. You just have to make sure that the two are separate and there's a delineation between the two. But yes, we have had concurrent inspections and investigations.
Hi, I'm John Leo. I'm the U.S. law perspective guy for tomorrow, and I just was curious in terms of environmental enforcement, either at the federal or the provincial levels. Are there, for purposes of pollution, you mentioned adverse effect as a standard for charging. Are there specific concentration levels for particular kinds of chemical compounds that have been established in regulatory contexts as a basis for setting floors below, or pardon me, floor above which you cannot go without creating an offense, so that you actually have a prescriptive standard by which to measure compliance, and therefore theoretically just assess what a gravity-based penalty, what the range of gravity-based penalties might be?
It's a great precedent. So, no. The general pollution prohibition is as it is. It's a narrative test. It is true that where the ministry has adopted a number by policy or regulation, so let's take, if it's by regulation, and you breach that standard in the regulation or your instrument, it's a legal requirement. So when you are charging, you can always decide, there's been this terrible pollution incident, am I going to use the general pollution prohibition, or am I going to basically say it's breach of the requirement? The consequences are the same. They're both third-tier offenses, and they both basically meet the same minimum fine. But adverse effect, what you raise, is a very good question, because it's all about overbreadth. There was a charter challenge back in 1995 about whether or not the adverse effect provision was unconstitutionally broad because of Section 7. And the courts said no. There is a de minimis sort of exception, which you don't see in this section, but they said, of course, if de minimis things, if you're prosecuted, the courts have discretion to go, this is de minimis, it's not covered. But otherwise, you simply go right to the narrative test, definition of adverse effect, which is in Section 1, and that's where you're there. So if you're in an odor complaint, you're literally calling odor experts and showing why there's been causing this discomfort to persons, et cetera, et cetera. So often it's not reduced to particular numbers.
No.
Hi. I was wondering about, in the old regime, let's say you have a spill over a 5-6 day period, you possibly lay one charge covering that time range, and then the court would have discretion as to what sort of sentence they want to impose. But now, if you lay charges for every day, but it's over a long course, and you have minimum fines, I can see the door opening for an abusive process in terms of how discretion is being used by officers or prosecutors in pursuing those charges. Has the AG in Ontario faced such arguments thus far?
Not that I'm aware of, but for example, Paul and I prosecuted the city of Ottawa for a discharge of effluent into the Ottawa River, and they were charged with not only the discharge but failing to report. And the discharge, as I recall, was almost 2 weeks. The fail to report was almost 6 months. So that the fines imposed if we'd gone for both the 2 weeks and the 6 months would have been off the wall. So what we did was we told the city that we would go with the 2 weeks for the discharge and the cumulative day-by-day penalties, but with the fail to report, we exercised some discretion and said that the fail to report had been essentially the first day when they became aware of it and didn't tell anybody. So rather than going for the fail to report for 6 months, we took the 1 day and still wound up with fairly substantial fines. So Crowns are allowed to exercise some discretion in the time periods if it's required.
Great.
Yes, Alexa Kajani from the Department of Justice. You mentioned earlier about Jarvis and Ling, and you talked about the threshold of crossing from an inspection over to an investigation. You talked about the test being the predominant purpose test. Now, I'm just wondering how you reconcile the decision that came after those two cases, which is R versus Nolay, and I believe that was in 2010, and that was confirmed in another case, Mission Western BC Court of Appeal, which was a fisheries case. And in those cases, they kind of distinguished Jarvis, and they talked about the reasonableness and the totality of the circumstances, a much more it looked like it was going back pre-Jarvis. So you talked about your agency using the Jarvis test. I'm just wondering how you reconcile the Nolay decision and the Mission Western case.
Well, I think that Jarvis and Ling is still the law. Decisions of the Supreme Court of Canada. And Supreme Court of Canada has said basically when a trial judge is trying to determine what the predominant purpose was, it's basically a factual determination. And it's been my experience that that's what the judges do, is they take into account the particular facts of that case and when it should have been apparent that it moved from an inspection to an investigation. And I think that's basically what judges will continue to apply.
So we'd also received an electronic question about no late, so I think that one's been dealt with. And just another one we have here, I wonder if the presenter would please name the recent decisions he just mentioned about the mandatory minimums as a starting point. Or perhaps if they're in the paper, I don't know.
No, it's not in the paper.
Okay,
We'll have to follow up.
okay, we'll follow up with that.
Sure.
Anything further? Okay, thank you so much for the two wonderful presentations.
Okay.